Welcome to Getting Help at Work, the Employee's Guide to Pregnancy Accommodation. This webinar is presented by the Center for WorkLife Law with generous assistance from the Kellogg Foundation and the Novo Foundation, and A Better Balance, the Black Women's Health Imperative, and the Women's Rights Project of the ACLU. My name is Cynthia Calvert. I'm the president of Workforce 21C and a senior advisor to the Center for WorkLife Law on the topics of pregnancy and family responsibilities discrimination. I'll be your host today. And I'm pleased and honored to share the screen with Dina Bakst, co-president of A Better Balance and a nationally recognized expert on pregnancy accommodation. So let's go ahead and start our presentation. What I'd like to do is tell you about several women, and each one is pregnant, and each one, is in the paid workforce. As is typical, each one is a breadwinner for her family, and she would like to be able to work as long into her pregnancy as possible. And I should tell you that each of these women is a composite. She's a mixture of women that we've met or who have brought discrimination claims in court. So the first person I'd like to introduce you to is Dina, and she's pregnant with her first child. She has gestational diabetes, which means she has to pay very close attention to what she eats and when she eats it, and she also has to periodically test her blood sugar. So she's talked to her supervisor about this, and the supervisor has allowed her to have the extra breaks, but makes her work late every day to make up for the extra time. Next we have Shauna, and Shauna is also pregnant with her first child, and she's been having migraines frequently. Her workplace is next to a paint department, and the fumes seem to make her headaches worse. She's also concerned that the fumes might be bad for her unborn baby, and she asked her supervisor if she could be transferred to a different location, but the supervisor said no, there just isn't another location available. Then we have Jessica, and she's having very bad morning sickness, and her morning sickness seems to last the entire day. She can't keep any food or water down. She's already been hospitalized once for dehydration, and she doesn't feel that she has the strength to go to work, but she's used up all of her sick days and she doesn't want to get fired, so she keeps trying to go. And finally, we have Julia, and she's pregnant with her second child. She had really serious complications with her first pregnancy, and this pregnancy is also considered high risk. And her job involves moving patients, and her doctor said she shouldn't lift more than 25 pounds. So she's asked for lifting assistance, but her supervisor denied her request. And the supervisor said she was going to have to go out on FMLA leave if she can't do her job. But she's trying to save her FMLA leave so she can stay home with her new baby for as long as possible. Now, in the past, these women would have had a difficult time getting the accommodations that they needed so they could keep working. In the last several years, though, new laws have been enacted on the state and local level, also on the federal level, that may help these women. And we also see some new regulations in the states and federal agencies and some new court decisions that may help as well. So today we're going to look at the legal and the practical ways that pregnant employees can get help at work. And Dina is going to share with us now some information about how to talk with your supervisor and let him or her know that you're pregnant and what sort of help that you need. So Dina, let me turn it over to you.
Sure. Thanks, Cynthia, and hi, everyone. So when to break the news? There are no real legal deadlines for notifying your employer until late in your pregnancy, when you will need to request 30 days in advance of taking off of childbirth if you are covered by the Family and Medical Leave Act. However, you may need time off earlier, for pregnancy-related conditions or complications or other needs. So if you need a workplace change to accommodate your pregnancy, you may in fact have to break the news earlier. There's no hardline rule about how to handle this. We encourage you to think about the effect on personal relationships when you do share the news with your boss. We say if you suspect your boss won't be happy to hear you're pregnant, don't feel pressure to tell before you're ready. However, do keep in mind the real practical implications and that your colleagues and boss may appreciate being told as soon as you feel comfortable so that they and you can plan ahead. We now turn to the next page. What to say? Well, before you say anything, get armed with information. Before you start the conversation, it's a really good idea to do your homework and review your employer's policies about pregnancy and parental leave, and depending on the situation, you may want to consult with human resources. What should you say? We encourage you to reassure your boss that you are committed to your job and that you plan to return to work after your baby arrives. Many bosses wrongly assume that pregnancy means the end of an employee's dedication and reliability. And it's important, as uncomfortable or as frustrating as that may seem, to tackle those assumptions up front. And we've seen that really be very effective in encouraging bosses and opening up to working through, pregnancy and beyond with a worker, with an employee. Stress, again, that you are willing and able to keep working. Even if your employee impacts your ability to work, it is short-term, like another temporary disability. It's going to be a blip in the long-term career, and so working with you is, not going to require major accommodations. You don't need a doctor's note to announce, your pregnancy, and in fact, a note up front, could cause trouble. So we just recommend, just in terms of sharing the news, to just inform your boss, inform your boss that highlight that you're a breadwinner or a primary earner for your family, and that your household depends on your paycheck. And you also want to offer to help transition work or to train a sub to really show that you're committed to make sure that your workplace operates effectively and seamlessly while you're away. Listen carefully and take notes about your conversation, especially if anything that sounded strange or wrong to you. As you'll learn more, unfair treatment based on pregnancy is illegal. So that is how to talk to your boss about announce your pregnancy. What if you need an accommodation? Okay, so you've had a conversation with your medical provider, and you believe that you need an adjustment to your job duties or changes at work to accommodate your pregnancy-related condition. So how to ask for an accommodation? You want to tell your boss about your condition and ask for a reasonable accommodation for your disability. Now, I'm getting pretty technical here. We're talking about a diagnosable medical condition or disability associated with your pregnancy, such as gestational diabetes, hypertension, severe migraines, fatigue, back pain, swelling in your feet. These are pregnancy-related medical conditions or complications that trigger the need for an accommodation under the Americans with Disabilities Act. And so you want to tell your boss the accommodation you need and be armed with alternatives. You want to be armed with how you're going to make it work. You're going to want to have armed with talk with coworkers who may be able to cover aspects of your job. So it's really a two-way communication. You may also want to explain how your requested accommodation will really not be too difficult or expensive for the company. Again, it's time limit. Another employee is willing to help you on occasion with a task you can't perform. The key here is really engaging in a two-way conversation, and you may engage with your boss, and your boss should engage back with you. So if she asks for additional information, again, we turn to the next page about doctor's notes. Your boss may ask you for a note to verify your pregnancy-related condition, and you should provide that note with a caveat. You want to make sure that your note is as specific as possible, and this is where employees really get tripped up. A note that says Jane cannot do any lifting is going to create a problem for you, because a boss may wrongly assume that that means that you can't do any aspect of your job, or think that, may have assumptions that, you're a liability in the workplace if you do anything that would violate this overly broad note. So what you want to do is come in with a very specific note, which goes to the specific restriction. So you'll see here, instead of no heavy lifting, you'd like a note that says no heavy lifting over 25 pounds. You want to really make sure, ultimately, if possible, that your note allows you to maintain to do the bulk of your job duties. And that may require you to have a conversation with your doctor about what your job is and what your main job functions are, and to make sure that, obviously, that your doctor recommends this accommodation, but also that you are you're not inadvertently handing in a note that's going to send you home. Now, doctors' visits. Well, one more point I want to say on that. You may be in a situation where when you hand in a note, a doctor could say, well, you can't do your main functions of your job, or you are if your boss does say things to you like you can't do the main functions of your job, you will want to recommend going back and getting a second note for clarifications. Again, this is a two-way exchange to try and get a note as specific as possible and to address your employer's concerns. On doctor's visits, you can use the FMLA if you're covered by the FMLA. The Family Medical Leave Act allows for using these prenatal visits, but again, that you have to be qualified and work in a workforce with 50 or more employees. And you need to follow the employee's rules as much as possible. So if your employer requires you to give notice, clarify when you are going to be able to return to work, and again, you must comply with requests for additional clarifications. What to do if your employer says no? So if you have a second chance for an accommodation, ask for it. So the doctors, they say, sorry, we don't have light duty, we don't have any desk job for you. There's no desk job available, but perhaps you could take more frequent breaks. Be open-minded to possible alternatives. If you don't get a response at all, we recommend you put your request in writing. Via email, a doctor's note, your own note. Be very specific about what you are requesting and why. You may need to get human resources involved if you're in a situation, A, where there's no response, or there's some, your manager is unsure about how to handle the situation. The other scenario that we have heard is your boss may something, and we have heard this, this creates a liability for us, or when you hand in a note, the reaction may be, well, better you should just stay home and rest. And these are, maybe very well evidence of pregnancy discrimination and bias that we would recommend at that point exploring, talking to an attorney, and because this may very well be evidence of pregnancy discrimination. Again, you want to try and make the accommodation work, but if you find yourself in a spot where they're unwilling to work with you, that's when we recommend that you explore your legal options. And on the next page, you'll see this is A Better Balance's Babygate website, where it's so important that to understand that there are federal and then a real myriad of state and local protections, both for pregnancy and leave and breastfeeding. So what this page does is breaks down your protections by state. And it includes the previous discussion I just went over about how to talk to your boss about your bump, and to also really look at each state law around where they may give additional unpaid leave rights or stronger breastfeeding protections. So to really, again, this goes to being armed with information, or you may very well qualify for paid leave, like in New Jersey, or additional unpaid leave, like in Tennessee, where you can qualify for 4 months of unpaid leave. Again, get as armed with as much information as possible, before you even engage in the conversation. This is a great resource for you. Now, thankfully, that there are states that go beyond these protections under the Americans with Disabilities Act, and there are many states have state counterparts to that law. And we list here the various states with statutory protections, explicit statutory protections providing accommodation: Alaska, California, Connecticut, Delaware, Illinois, Maryland, New Jersey, Texas, and West Virginia. And it's not all in that order, but to save the time here. On the next page, we talk about the local jurisdictions that have enacted counterparts to the similar pregnancy accommodation laws. New York City actually was the first of this new bunch, followed by Philadelphia, Providence, Rhode Island, and Washington, D.C. And these laws basically make it explicitly clear that you may not necessarily have to have a pregnancy-related disability under the ADA that substantially limits a major life activity that would trigger disability law protection, but basically they either require accommodation for a broader range of pregnancy-related conditions, or as you'll see, well, I'll talk about Philadelphia in a second. California actually was the first of the wave of these accommodation laws, and it's been highly effective in keeping pregnant workers on the job because the law is so clear that it's basically in California it's illegal for an employer to refuse to provide reasonable accommodations to an employee for a condition related to pregnancy, childbirth, or a related medical condition. Your employer basically has to accommodate many needs that you have at work because of childbirth or pregnancy or childbirth. If you have the accommodation, if you ask for the accommodation with the advice of a health care provider. You can also get a transfer to a less strenuous or hazardous position because of pregnancy if the transfer is reasonable. For example, if they don't have to create an entirely new position for you. So California's law is, really been a powerful tool and a model for many other states. Following California, there is Connecticut. Now, Connecticut is a more limited law. They don't have a broad accommodation law. Their law says that employers have to try to transfer pregnant employees if their current position puts the employee or fetus at risk. So this is a much more limited protection, but it certainly, it prohibits refusing to provide temporary leave or temporary transfer. So, and again, you see this is protection for both the employee and the fetus. On the next page, you'll see Philadelphia. Now, Philadelphia's law is modeled right after New York City. This went into effect about 2 weeks after New York, maybe a little longer than that, after New York City's law, which passed an ordinance that requires employers to provide reasonable accommodation to employees for needs related to pregnancy, childbirth, or a related medical condition, so long as such accommodation will not cause an undue hardship to the employer. What's unique here about Philadelphia and New York City is that it doesn't expressly require a doctor's note, and the real standard here is whether it causes an undue hardship. And here in Philadelphia and New York City, particularly I know in New York City where the standard of undue hardship is really pretty high. So it has to be a significant burden or an expense. So in these jurisdictions, employers really should be prepared to accommodate a wide range of medical needs arising from pregnancy, whether it arises out of a healthy pregnancy or out of a complication. So for example, pregnant workers that may need to drink extra water on the job or a stool to sit on, these laws will help those women who may not yet have a pregnancy-related complication, but need an accommodation to prevent complication down the road. And in fact, these laws have been used in the year that they've been in effect and been proven to be highly effective at keeping pregnant women healthy and on the job. And then next, you'll see here the ACLU's wonderful map. They have a state-by-state map that also shows which states have pregnancy accommodation and breastfeeding laws, where you can just click on your state and see states that go beyond federal protections and disability protections to explicitly ensure accommodations for pregnancy. So with that, I'll turn it back over to Cynthia.
Great. Thank you so much, Dina. I appreciate that. You'll see on the map that I've drawn some circles around the dark blue legend at the bottom that says State Pregnancy Accommodation Law, and then the dark purple that says both breastfeeding and pregnancy accommodation laws. Those are the states that are most protective. There's a lot more information in your handout about state laws. So if you want to see exactly what's going on in your particular state, you can get access to this map through the link in the handouts and just click on your state and get all the specific information. So let's switch gears a bit, because not all of those state laws apply to everyone, but there are some federal laws that apply to most employees. And the one that's most important that I'd like to focus on the most today is the Americans with Disabilities Act. It applies to employees who work for employers that have 15 or more employees. So it really does cover most of the workforce. And it does two things. First of all, it protects employees who have disabilities from discrimination. But second of all, and probably most important for our purposes today, it requires employers to provide reasonable accommodations so that employees who have disabilities can continue to work. And as we saw with the state laws that Dina was just discussing, employers don't have to provide accommodations if the accommodations would require an undue hardship. That's just another way of saying if the accommodations would disrupt the business too much or if it would be too expensive. And there are specific tests under the laws that we don't have to get into, but it's just important to know that that limitation is out there. You can't request just anything. So you may be saying to yourself, well, this is fine and good. She's telling me about disability, but I'm pregnant. I don't have a disability. What does this have to do with me? And you're absolutely right. Under the ADA, a normal pregnancy is not a disability, and it's always been that way. But the law was amended fairly recently. It was effective 2009, and what the amendment did is it allowed people who have temporary impairments that make it difficult for them to work to get accommodations. So in other words, temporary impairments now can be considered disabilities. And before the amendments, courts had said that pregnant women couldn't get accommodations even if they had a condition that would be considered a disability, like migraines, simply because if the condition is related to pregnancy, it's temporary. So fortunately, that's changed. That is out the window now. Now, there are other changes to the law that make it possible for pregnant employees to get accommodations as well. If a pregnant employee has a condition that makes it hard to do things like lift, stand, bend, eat, sleep, things that are pretty central to your life activities. Or if a pregnant employee has a condition that affects bodily functions like the circulatory system, the reproductive system, the gastrointestinal system, she might be considered under this law to have a disability. Gestational diabetes is almost always going to be considered a disability, and that makes sense because diabetes for non-pregnant employees is usually considered to be a disability, and that's the same with migraines and sciatica and carpal tunnel syndrome. I've been using some weasel words, some lawyerly words there, like may be considered and generally, and that's because there aren't any hard and fast rules about what is going to be considered a disability under this law. It depends instead on the severity of the condition and the impact that it has on the individual. So for example, if you get one migraine every other month, it lasts for maybe half a day, and you feel out of it for maybe most of the next day, that probably isn't enough to be considered a disability. At least I would say it's probably a borderline case. But on the other hand, if you had really frequent migraines and they lasted longer and they had after effects that made it difficult for you to read or to think or to learn, then quite possibly you would have a disability under the ADA. So there's one thing I want to clue you in on here, and that is that a lot of employers and lawyers and I hate to say it, but even judges are not familiar with how this law has been changed. So you might find yourself being in a position where you have to educate them about this. For example, a situation that could come up is, let's say you have severe morning sickness and you ask your employer for a reasonable accommodation. Maybe it's changing your schedule to let you come to work later each day, or maybe it's even letting you take some leave from work. And the employer might say, oh no, you don't have a disability, I don't have to accommodate you. And so you're going to need to be able to respond that you do have a disability because you have an impairment, and that impairment is the nausea and the vomiting, and that impairment affects a major bodily function. So in this case, your gastrointestinal system. And you can also say, you don't have to, but you also can say that the severe morning sickness limits your ability to eat, and maybe it also limits your ability to stand or to do other things. And you probably will have to tell your boss that it doesn't matter if it's temporary. So all of that can be kind of daunting. How do you know what to say? And your case may be different. There are resources out there to help you. There are some free hotlines that you can call that will help you figure out what to say. There's information about these hotlines in your handout, and we're also going to give you the contact information for a couple of them later in this presentation. All right, so you figured out that you may have a condition that's a disability, so what do you do with that information? The ADA, first of all, it's important to remember, says that you can't be fired for having that disability. And then secondly, as we've been saying, the employer has to accommodate you. And we're going to talk more specifically in just a couple minutes about the sorts of accommodations you can get. And it could be something like letting you have food at your workstation, or giving you more breaks, or giving you help with lifting. And we've already said that the employer doesn't have to give you an accommodation if it would cause a hardship to the company, an undue hardship. But you should know that there are a couple of other limitations in the accommodation area as well. The first is you're not entitled to get the exact accommodation that you want. Maybe you can negotiate for that, and that would be great, but you're not necessarily going to get what you want or what you think would be the best. What you're entitled to is something that will enable you to do your job. So, for example, let's say that you ask your employer to let you move to a beautiful corner office that's right next to the bathroom because of your morning sickness. Your employer doesn't have to give you that big, beautiful corner office with the great views, but could give you an office that's equally close to the bathroom, but it's small and it's windowless. So that's, it's a very silly example, but it gives you an idea. And sometimes accommodations are going to involve moving pregnant employees to different positions, and that's going to be considered a reasonable accommodation only if the position already exists and it's vacant. So the law doesn't require the employer to create a position or to move an employee who's already in a position in order to make room for you. So let's talk a little bit more about how this works. Once you tell your employer that you have a pregnancy-related condition and that's making it hard for you to work, or if you actually use the words reasonable accommodation and you ask your employer for an accommodation, you and your employer are supposed to have a back and forth conversation. That's the two-way conversation that Dina was just talking about. And you're supposed to talk about what you need and the best way to provide it for you. And the ADA has a term for this. They call it the interactive process. A lot of times the employer's not going to do this. We get a lot of calls to our hotlines. We see a lot of court cases where employers just say no, and that's the end of the matter. So you may need to document with emails or written notes that you've asked for help, and you may need to go to HR and get HR involved. The employer has to know enough about your condition to be able to determine that you more likely than not have a condition that would be considered a disability under the ADA. So that means that the employer can ask for medical documentation such as a doctor's note that says what you can do and what help you need, and this is just the same as what Dina was talking about before under some of the state laws. And as Dina said, it's very important that your doctor's note be as specific as possible, because if it's very vague and it makes it sound like you can't work, then the employer may be justified in forcing you to take leave before you really want to. So there's another law that we need to talk about, and that's the Pregnancy Discrimination Act. And it says that pregnant women are to be treated the same as other employees who are similar in their ability or inability to work. And what that means is, if your employer gives a male employee who has a bad back help with lifting, then the employer should also give a pregnant employee who has a bad back help with lifting. So as another example, and this probably comes up even more frequently, if a non-pregnant employee is allowed to be out of work for a temporary medical condition, maybe it's to have surgery or to recover from a heart attack, and that employee's job is held open and that employee is allowed to return to his or her position, then a pregnant employee should be allowed to be out of work for a medical reason. It could be a condition related to pregnancy, it could be for childbirth, and she should be able to have her job held open and she should be able to return to her job. But a lot of times women will call our hotline and they'll say, we just need 2 or 3 weeks off for childbirth, but they'll tell us they're new employees and they're not eligible for maternity leave under the employer's policy and they're not eligible for FMLA leave. So a lot of times this law may be a way for them to get that leave that they need. Now, you may have heard about a case that was recently in the news, recently decided by the Supreme Court, called Young versus UPS. And this case involved a pregnant employee who was told she couldn't have light duty, even though her doctor had recommended it, because only employees who had been injured on the job could have light duty. And the court said that employers can't have rules like that if the rules place a burden on pregnant women and the employer's reasons for having the rules aren't very strong reasons. So as a result of this case, most employers, we predict, are now going to change their rules that limit light duty to employees who are injured on the job, and more of them are going to make it available to pregnant women. And if you've been denied light duty because your employer has a rule like that, you may want to call one of the hotlines that we're going to tell you about, or you may want to call another legal hotline to get more information, because you may need to have a lawyer step in and help your employer understand why that rule is probably no longer legal. And before we leave the PDA, I just want to make sure that I remind you that the PDA also prohibits discrimination against pregnant women because they're pregnant. Your employers can't treat you more harshly or harass you or refuse to give you training or promotion or other opportunities just because you're pregnant. So, for example, if pregnant Pam's boss yells at everyone when sales are low, then there's, probably no discrimination. He's treating everybody the same. But if pregnant Pam's boss yells only at Pam when her sales are low and other employees who have low sales are not yelled at, then there might be discrimination, particularly if, in addition to yelling, the boss also is giving a bad evaluation or taking away a bonus or having some other negative effect on pregnant Pam's career. So let's switch now to a law that Dina mentioned, the Family Medical and Leave Act. This one is very important for pregnant employees, but it covers only about half of the workforce. It gives pregnant employees protected time off for pregnancy conditions like morning sickness, and also for childbirth, and also, as Dina mentioned, for prenatal doctor's visits. Now, to know if you're covered by the FMLA, you need to know that it covers only employees who work for an employer that has 50 employees or more within a 75-mile radius of the work site. Also, in order to be covered, employees have to have worked for the employer for 12 months, at least 12 months. They don't have to be consecutive. You can work a few months, take a leave, then come back and work a few more months. But it has to be a total of 12 months. And you have to have worked for at least 1,250 hours in the prior year. So that works out to be about 25 hours a week on average. If you're covered, then you have up to 12 weeks of protected leave to take per year. So this is a highly technical law, as you can tell. If you have questions about whether you're covered, you can usually just talk to your HR department and they can let you know. But also you can call a hotline or talk to lawyers and get the information that you need. So I've been talking about protected leave. I've said that a few times. What that means is you can't be retaliated against for requesting or for taking leave. And it also means that if you take leave, you have to be reinstated to your job when you return or given a substantially equivalent job. And one thing to know is that you have to give at least 30 days notice of your need for leave in order for your leave to be protected. And that's not hard in the case of childbirth. You usually know what your due date's going to be, but it's impossible usually for a pregnancy-related condition or if you go into labor early. And in those situations, what the law says is you're required to notify your employer as soon as you can of your need for leave. Employers are allowed to ask you for medical certification, like doctor's notes. And they can ask for a note to show that you're pregnant or to show that you have a pregnancy-related condition that's serious enough that it justifies leave. If you don't want to disclose your pregnancy yet, you can ask your doctor to write a note that just focuses on the condition that requires leave and doesn't disclose the pregnancy. So the FMLA does not require you to disclose your pregnancy. So let's go back for a moment and check in on those people that we met at the beginning of the presentation and see how these laws would affect them. In the case of Gina, her employer is giving her breaks, and so she's already getting the accommodations that she needs. The issue is whether the employer is right to make her make up the time. And chances are the employer is. It's going to depend upon whether she's an hourly or a salaried employee, and so we would probably tell Gina it's a good idea to go and talk to a lawyer and see if the employer is within its rights to have her make up that time. Now with Shauna, she asked for a transfer and she was denied. If she works in a state that has a pregnancy accommodation law, the law might require the transfer. As Dina mentioned, there are several state laws that specifically say if the employer has a policy or practice of transferring other non-pregnant employees when they request, they have to do the same thing for a pregnant employee as well. But also, under the ADA, if her migraines are serious enough to rise to the level of a disability, she might have to be accommodated there too. So in this situation, her employer says there's no place to move her, and that's where the interactive process comes into play. There might be some places that she can work that the employer hasn't thought about, so they can talk that through. Or it might be that there's an alternative, such as she could work from home. So Jessica was the one with the morning sickness, and she is out of sick days. It's important to know that she probably still can take leave, assuming that that's what she wants and what she needs, and she might get that right under state laws. Several state laws require pregnancy disability leave to be available, and sometimes it's longer than FMLA leave. There are a couple of states, I believe, that have 4 months of leave available. But also, she can take leave under the FMLA for morning sickness, assuming that she's covered by that statute. And the ADA can also require leave. And then Julia, of course, she needs help with lifting, and state laws and the ADA might both require the employer to provide her with that help. And then, of course, if she is in a workplace where non-pregnant employees have been given help with lifting, then the Pregnancy Discrimination Act might also require the employer to give her help with lifting. And leave really should be a last resort. So here's the information about the hotlines that I mentioned to you. WorkLife Law has a hotline that you can access by sending an email to hotline@worklifelaw.org or calling 415-703-8276. And A Better Balance also has a legal hotline, and its number is 212-430-5982. So what type of help can you get? We've been talking about accommodations without being very specific, and of course it's going to depend upon your particular needs and how you need to be accommodated so that you can continue to do your work. But the sorts of things we see commonly are bathroom breaks, breaks to take a break just to rest or to go and get some water, maybe to walk around, clear your head, help with lifting or with carrying things, light duty or transfer to less strenuous or hazardous work, and having an accessible work site, meaning a work site that you can easily get to and move around in, such as not having to climb ladders or walk a very long distance if you're having difficulty with walking. Also, you can get changes to your schedule so that you can arrive late. Again, that's subject to the undue hardship rule, or maybe a change to your schedule is to work fewer hours or to compress your work week so that you're working 4 longer days and taking a day off. It can be something as simple as a chair to sit on. We talked about being moved to a vacant position. Sometimes people need to have the equipment that they use in their job be modified, such as something being raised up so that they can work while they're in a standing position. And of course, time off for medical appointments and medical leave. So let's talk a little bit more about leave, because it's something that concerns a lot of people, and we see a lot of legal issues surrounding leave. If you take leave under the FMLA, for a prenatal appointment or to deal with a pregnancy-related condition, it does count against the total of 12 weeks that you have for all of your pregnancy, childbirth, and child bonding. But as I mentioned, some states do have longer leave times, and there are 2 jurisdictions, and maybe there's more, but there are 2 that I know of, DC and California, allow leave stacking, where pregnant women can take FMLA leave for their own medical condition related to a pregnancy problem. So, perhaps it's morning sickness or migraines, but then when they give birth to their baby, they can take family leave as something entirely separate, and they can have time to recover from childbirth and time to bond with their baby. And so in California, I believe that pregnant women can get up to 28 weeks of leave if they stack their different types of leave. In DC, it could be as much as 32 weeks, I believe, because they allow 16 weeks, and that is allowed every 2 years instead of every 1 year. One thing that's also important to know about leave is if you can't return at the end of your leave because you still have some physical or some mental conditions that make it difficult for you to work, the ADA might be a source of help for you there. Leave is a reasonable accommodation under the ADA, but it can't be open-ended. Your doctor has to be able to say that you are likely to be able to return to your job after 6 more weeks or something along those lines, so that it's not just left open-ended, because the courts have said that if there is no return date anticipated, that is an undue hardship on the employer. Now, I should note that we're going to go a bit over our time. I had said that we would be done in 45 minutes, and we're probably going to be maybe 10 minutes beyond that. If you need to jump off, please do. We're going to be recording this and making this available on the WorkLife Law website, so you'll be able to come back and see anything that you missed. So let's talk a little bit more about changes to schedule. One thing we have not mentioned today is that under the FMLA, you can take your leave in a continuous block, 12 weeks all at once, or you can take it intermittently, which means you take it as you need it, a few hours here for a doctor's appointment, a day here for a bad back. And you also can take FMLA leave on a reduced schedule basis. And so that just means that every week you're going to work 30 hours instead of 40 hours, and that time that you're not working is going to count against your 12 weeks. But that's not the only way to get flexible work. You can make an agreement with your employer, or you can use your employer's flexible work policy and change your hours that way. Under the ADA, schedule changes can be a reasonable accommodation, particularly if it's something that's going to enable you to continue doing the essential functions of your job. And under the PDA, the Pregnancy Discrimination Act, if the employer allows other people who are similar in their ability or their inability to work flexibly, then the employer should allow you to work flexibly as well. And then also under some state and local pregnancy accommodation laws, we have provisions that say schedule changes are a reasonable accommodation. So many different avenues to explore there. And light duty, of course, is a big issue as well. And as we've said, it is available under the ADA. And, of course, you need a condition that rises to the level of a disability. And as we said, the employer doesn't have to create a position for you. One thing that's important to know is that you have to have the ability to do the light duty job. Light duty is also available under state and local laws. Usually it has the same proviso as the ADA, that it cannot work an undue hardship on the employer. So your right to light duty is not absolute. And under these state and local laws, the light duty accommodation may be available even if you don't have a disability. So let's switch gears for a little bit and talk about ways to make it easier to work while you're pregnant. And of course, everybody has a different situation. What we've done is we've gathered some tips from our own experience and from suggestions from pregnant women about how to be more comfortable while they're working. So the first tips are really just about trying not to do too much. Sometimes we want to prove ourselves and we don't scale back even though we're really exhausted. And this can be really damaging. It can be damaging to your performance and your reputation, and it's particularly hard if we don't know how pregnancy is going to affect us, and so we promise to complete work by a deadline that's too ambitious. People will just say, oh, there she is, she's always missing deadlines, she's not reliable anymore because she's pregnant. So one tip is to figure out when you can have a project done by and then promise the project several days after that. And then that way, if you need more time because you're just so exhausted, you can have more time with no problem. Nobody's expecting the work. But if you're done early and you turn the work in early, you're an absolute hero. A lot of women suggested conserving your energy, and some said that they take naps even in their cars during the workday, and others have cut back to part-time, and others make sure that they can really rest when they get home by outsourcing all of their household chores. And of course, every employer's policies are a bit different, so knowing what your employer expects and is willing to offer with respect to pregnancy and maternity is very important for your planning. Obviously, you want to know if there's a maternity leave policy and if it's paid or not, but you might also want to look at your benefits while you're on leave. And importantly, you may want to know what happens to your benefits if you don't return from leave. Some employers have policies that say if you don't come back after leave, you have to repay your benefits. And you may want to check and see if your employer has policies about flexible work or a gradual return to work that will be helpful to you after you've had your baby. You may want to see if there are things you can do to make it more comfortable to work. Some people find that it helps to prevent back issues if they can alternate between sitting and standing, and I heard from some women that they like to have a box so that when they're standing, they can put one foot up on the box and relieve some of the stress on their lower back and then shift periodically. If you're nauseated, having a bit of food handy and avoiding strong smells might help. One of my friends always brought a change of clothes to the office, just in case, and I always had ginger candy to calm my stomach. Walking outside may make you feel better, and you may want to look for ways that you can modify your work so you don't have to walk as far or as often if walking is bothering you, and see if you can use a cart or a dolly for carrying things. We often find that bosses and coworkers make a lot of assumptions about pregnant women and how they won't be committed to their jobs or they won't be dependable, and they assume that pregnant women won't come back to work after they have their babies, and all of that can affect the opportunities that you get while you're still pregnant and while you're still working. So you can address those assumptions by just sprinkling your conversations with things like, I'm really committed to my job, and when I return from leave. As we sort of alluded to before, if you're going to miss a deadline, that's kind of a critical area. You want to make sure that you let people know in advance you're going to miss it, but then you want to tell them why so that they don't assume it's because of your pregnancy. So for example, you would say, hey Jane, I'm going to be late with the Smith matter. I'll have it to you on Tuesday. I've been really tied up on the Jones matter. And then that way Jane's not going to make the assumption that the reason why you're late is because you're pregnant and pregnant women are always undependable. And you also want to make sure, as Dina mentioned, that you transition your work so that everything goes very smoothly while you're out on leave, and leave your files and your workspace organized when you go out on leave so people can find things. Because you know they're going to be calling you at home and they're going to be saying, I can't find the Jones file. One piece of information you should have about that is if you're out on FMLA protected maternity leave, it's okay if your boss calls you every now and again for information, and it's okay for you to call the office and say, you know, everything's going great, miss you all, but it's not okay for your boss to give you work to do while you're out on protected leave. If that's happening to you, it's probably time to call a hotline or talk to a lawyer. So finally, you want to make sure that you know your rights under the law, that the rights that give you the right to maternity leave. You also want to make sure that you and your employer are on the same page with respect to how long you're going to be gone. We hear stories of a lot of miscommunication about when somebody's return date is. And it's usually good to check in with your employer a couple of weeks before you return, just to remind everyone that you're coming back and make sure that things get set in motion to transition your work back to you. And when you do return, you want to make sure that you stay aware to make sure that you're not discriminated against because of motherhood. Unfortunately, this is something that we see fairly frequently, and you can get more information about that from WorkLife Law and also from A Better Balance. We've put links to the websites for both organizations in your handout materials, and both of them have information about maternal wall discrimination. So that brings us to the end of our presentation, and I would like to thank Dina for sharing her wisdom. If you have any questions or comments, please let us know. I've put our email addresses on the screen: Cynthia Calvert at worklifelaw.org, D. Bakst, that's DBAKST, at abetterbalance.org. I'd like to thank you for participating. I hope you found this useful. As I mentioned, a recording of this webinar will be available on the WorkLife Law website, so please let your friends know about it if you think it's something that they would benefit from. And Dina and I wish you all the best with your pregnancies and with your new babies. Thank you very much.